attorney Emily Anderson with RSH Legal. Although some employees are lucky and have positive experiences when dealing with the workers' compensation insurance company, it is critical to recognize that insurance companies are not on our side. Oftentimes, employees report a legitimate claim to their employer, which is passed on to the workers' compensation insurance company, and it results in a denial. Here, we will review the types of denials that injured workers regularly contact our office to discuss. Number 1, the insurance company says there's no employer-employee relationship. To have a valid workers' compensation claim, there must be an employer-employee relationship. If the employer can undercut this first element, the entire claim fails. Most commonly, this occurs where an insurance company says that an employee is actually an independent contractor, a class of employees not covered by Iowa workers' compensation. However, it is important to recognize that there are not necessarily clear divides between employees and independent contractors. In these types of situations, you should consult with a workers' compensation attorney to help you make this determination. Number 2, an insurance company says there is no qualifying work injury. This can happen in a few instances. If you have a pre-existing condition, the insurance company may deny your claim. However, a pre-existing condition does not mean that your claim should automatically be denied. Under Iowa workers' compensation law, an injured worker is entitled to benefits if a work activity aggravates, accelerates, worsens, or reveals an underlying pre-existing condition. Whether or not a particular claim is covered depends largely on the medical evidence, in particular, the treating doctor's opinions. Many cases involving an aggravation of a pre-existing condition, which are initially denied, are ultimately determined to be covered after an experienced attorney properly questions a treating doctor. Next, your injury may be denied based on the insurance company's reasoning that it was not caused by your employment. There must be a connection between the injury and the employment. Specifically, the injury must be a result of the employment. It must arise out of and in the course of your employment. This may sound like legal jargon, but it is very critical to bringing a workers' compensation claim. Simply put, the injury must be caused by the employment. It is common for insurance companies to attack the validity of a work injury in relation to whether the employment caused the injury. Next, an insurance company may tell you that you did not give proper notice of your work injury. Most people are aware that there's some type of statute of limitations for workers' compensation claims. What they may not be aware of is that there is an additional notice requirement for workers' compensation claims. In order to have a valid claim, the employee must give notice to the employer within 90 days of the work injury. It is a terrible thing when someone has a valid workers' compensation claim, but it is denied because they did not give proper notice. Consult with an experienced attorney to ensure that this situation does not happen to you. If you need additional information, please download our free law guide to Iowa workers' compensation claims at www.fightingforfairness.com.